Good morning. I'm attorney Gary Finklea. This morning I'm speaking to you from the Florence City County Complex, and specifically the jury room in the 10th floor courtroom. This morning I'm present in regard to a hearing relating to entry of a deficiency judgment against one of my clients. Unfortunately, my client doesn't have many defenses to the entry of this deficiency judgment. I've spoken to you before about a deficiency judgment. In this particular case, there were multiple properties, and what happened, the bank foreclosed. The property was sold on the courthouse steps, and the difference between what it was sold for and the amount that the client owed the bank is called a deficiency. There are some defenses in foreclosure cases to the entry of deficiency judgments, and those defenses depend first whether or not it involves real property or personal property like a car. In both cases you can have deficiency judgments. In the case of cars, when cars are repossessed, they're generally sold at auction, sometimes by private sale. In order for the lender to obtain a deficiency judgment against the creditor, in that case, or against the debtor, in that case, they must follow certain rules regarding a commercially reasonable disposition of the collateral and comply with the Consumer Protection Code. Now, oftentimes that's not done, particularly as it relates to local lenders or local buy here, pay here stores. Generally, we can always get a client out of those types of collection matters or those deficiency judgments. However, the more sophisticated lenders generally follow the proper procedure, and it's a little more harder to relieve a client from entry of a deficiency judgment. As it relates to real estate, again, there are very few defenses in regard to that, but what we try to do is help on the front end before deficiency judgment results. Particularly in consumer cases, we look at various law violations, such as violations of the Consumer Protection Code, the Attorney Preference Statute, Truth in Lending Act, Real Estate Settlement Procedures Act, and a number of other statutes that are on point, and they often provide a defense. In this particular case that I'm here on this morning, it is a commercial foreclosure, and therefore those consumer defenses are not present. Generally in commercial cases, the only two defenses that we have is first, that the plaintiff, that the lender is the holder in due course of the note and they have a proper record of that. And second, in the event that the property sold on the courthouse steps sells for less than its fair market value, the debtor, defendant, can use or assert what we call the appraisal rights. And the appraisal rights are rights guaranteed under the South Carolina Code. Now, the problem with that is generally lenders require borrowers to waive their appraisal rights when a loan is made. But as in many cases, the borrowers don't do, or the lenders don't have the proper paperwork and don't follow the proper procedure. What a lender is supposed to do is to provide the borrower notice before the loan is signed that they're waiving the appraisal rights. Generally, the lender only gets that document signed at closing. Therefore, it's not before the closing. So we use that oftentimes to defeat the deficiency judgment. In this particular case, we didn't even research that issue or use that factual basis because the bank was the high bidder on the courthouse steps in all but one of these cases, and what the bank bid the property in at is what we think the fair market value of the property is, so we didn't lose anything in that regard. So this morning is just formality, but nonetheless, hopefully that will give you some information in regard to deficiency judgments and what happens. You know, when this deficiency judgment is entered, it's going to be a judgment against the defendant, the debtor's record. The judgment remains for 10 years, and now that the bank, if there's any non-exempt property, the bank can seize and execute against that property and have it sold and apply any proceeds to the satisfaction of its judgment. If any real estate is sold, the bank, since it will have a judgment, will have to be consulted. Any proceeds received will have to be paid to the judgment creditor, the bank in this case, and the judgment creditor, the bank, can approve or disapprove sales. Because if they see that my client's trying to sell property for less than its fair market value, they can object to that and not consent to the sale and partial release its judgment from the piece of collateral. In any event, if we can help you with this or any other matter, please feel free to give us a call at the Finklea Law Firm, 843-317-4900, or you can reach me by the internet or by email at gfinklea@finklealaw.com, and our website is finklealaw.com. Thank you very much and have a good day.